How not to end up with 20 million when you're expecting billions of dollars? Let me explain you this with a story of a company called Neonode. Neonode is a Swedish company, and in 2002, they patented a very important touch and swipe gesture, years before we saw in Samsung and Apple devices. In fact, back in 2005, Samsung even took a license from Neonode for this patent at a hefty amount of 1.5 million euros upfront and a running royalty of €2 per device. However, in 2008, Neonode went bankrupt and Samsung suddenly stopped paying. Now, fast forward to 2020, this feature was used by everyone, by Apple, Samsung, and Google. Now, Neonode suddenly decided to sue both Apple and Samsung. And considering the past licensing deal with the Samsung, some analysts predicted the valuation at hundreds of millions. In fact, one conversation between Neonode's founder and external law firm pointed to a valuation of $50 billion. However, in September 2025, the judgment finally came and Neonode was awarded only $15 to $20 million after deducting the lawyer's fee and external firm's fee. Now, this raises a very important question. How do you value a patent? Patent valuation can be a tricky subject. Under Georgia-Pacific framework set up by US Court, there are around 15 different factors to assess the patent value. And to make things more complex, there are around 8 valuation approaches for patent valuation. In the Neonode versus Samsung case, one must ask these very important questions. Does the swipe gesture still generate any revenue for Samsung? Or has its commercial value diminished over time? What is the realistic amount of licensing fee that other parties are willing to pay for a patent? We recently conducted a valuation study to help our client answer these very questions before entering into the litigation battle. If you would like a pre-litigation study to understand the value of your patent, we would be glad to help you.